So when you start an employment relationship, there's a few things to keep in mind. We noted that today is going to be focused on these issues from a New York perspective. If you're joining the call and, you're from another state, welcome. We're glad to have you. But, some of this may not be the same in where you live. You'll want to find out for sure what the situation is where you live. For instance, California is a little different on some of these issues. But generally, most states are what's called at-will employment states. And that means, unlike certain European countries where you're required to have a contract of employment, that's not the case in the United States. And you're not entitled to any protections as an employee against termination or changes in job, et cetera, unless you have an employment agreement and a contract with the company. So when you start, there's different ways that relationship can be created. It can be created through an offer letter, generally after there's been some engagement, sometimes through a recruiter or otherwise. When you're far along in the process, you've already discussed maybe what the terms of compensation or the terms of employment might be. The company presents you with an offer letter or an employment agreement. I mentioned, that sometimes that offer letter comes late in the process. So it's really important to be thinking about these issues from the very beginning of conversations. Thinking about where do you want to position yourself in terms of, what you're asking for in compensation, what they're offering you in compensation. Thinking about, what your expectations are with respect to equity grants, options, anything like that, so that from the very beginning, you are setting expectations and not just being reactive to kind of what they offer you. But generally, in an offer letter or an employment agreement, we're looking at a few things. What's the title? What's the reporting lines? What are your duties and responsibilities? Where are you going to work? These all matter. We'll talk a little later about the pay equity laws that exist. But these can be important in terms of, again, establishing where you're going to fall within the hierarchy of the company and what the idea is on both sides about what your job's going to look like. It's important, most bonuses, companies have language in there where they're offering you some sort of incentive compensation, a bonus that is discretionary. And if you're expecting that the bonus is going to be, a material part of how you're paid, or the equity is going to be a material part of how you're paid, you're going to want language in an agreement that really makes that clear, that it's not discretionary, it's an expectation, it's an obligation that the company has. Benefits should be spelled out. How are you going to be treated? Are you, kind of at the bottom of the hierarchy? Are you higher up? What's the different benefit plans that are provided to you? These are generally uniform across the company. It's not typical that you're negotiating for special benefits unless you have a special circumstance, right? So if you are here working on a visa and you know that you're going to want to travel home and there's an expectation that the company is going to pay for your travel once a year, that's an additional benefit that you should be talking about from the beginning. If you're pregnant and you're starting the job and you know that you're going to take, maternity leave, but maybe you wouldn't otherwise qualify for the company's, parental leave benefits, you might want to negotiate on the beginning that you're going to get those, notwithstanding the fact that maybe you won't have been there long enough. You also want to think about, at the beginning, what's going to happen at the end? What happens when the employment relationship is going to end? And so very often in these employment agreements, there are, obligations around how much notice you're going to give the company, how much notice they have to give you if you're going to terminate the employment relationship, or they're going to terminate the employment relationship, what kind of severance entitlements you might be entitled to, how your equity, how your options are going to be handled. Are your options going to vest if they terminate your employment without cause, or are they going to be forfeited? How long are you going to have to exercise those options if there's a termination event? Does the company have the right to buy back options or equity that's been awarded to you? You want to be thinking about all of these things at the front end. Why? Because your leverage is usually strongest at the beginning of the relationship. Everybody's excited, it's a new event. And there's ways that diplomatically you can advocate and negotiate for yourself, even at the front end without kind of spoiling the relationship. Very often too, and this is critical, employment agreements or offer letters or handbooks include what's called arbitration clauses. And this is where the company is obligating you, if anything happens and you have any sort of disputes in the future that relate to your employment, you have to take them to arbitration instead of to court. Now, why does this matter? It matters because arbitration is usually a private, confidential process, whereas court is a public process that kind of exposes the wrongdoing of the company. There's also differences in what kinds of information you're entitled to in arbitration versus in court. Now, it's not to say that there's never a situation where arbitration might be a good thing for an employee, but it should be the employee's choice, and it should be a choice that you make at the time the dispute arises, not something that's kind of forced on you at the beginning of the relationship. So, keep an eye out for that, because the other part of arbitration clauses is that it generally restricts your right to join with other individuals to try to pursue your rights. And we'll talk later about, the group actions, but there's power in numbers. And that's why the employers don't want you to have that right. That's why they put in the language that says you're waiving your right to join with anyone else. You're waiving your right to talk about it. And again, there may be an ability to opt out of that arbitration clause if you do it at the beginning. But once you start working, once you've kind of signed on to that arbitration clause, you're bound by it. And the good news is that some employers are feeling public pressure to withdraw arbitration clauses. So we saw how Google, in response to the powerful advocacy of its own employees, elected not to enforce arbitration clauses. Our case against Google now is a direct result of that. Our client is in court. Everybody's able to follow along with that case because the company, because of the advocacy of its employees, withdrew those arbitration clauses. An important note about prior salaries in the negotiation process at the beginning of your employment. Historically, underpayment for women and people of color followed them from one job to another job. So if you were paid at your employer and you wanted to leave, that legacy of underpayment would go with you, because the next employer would say, well, how much were you paid? How much are you being paid? And then they would use that as, the threshold, as the benchmark for how much they were going to pay you in the next job. And so kind of the legacy of pay inequality would follow from one job to the next job to the next job. A few years ago, New York State addressed this by saying that it's unlawful for employers to inquire about what your prior salary was. It's unlawful for them to ask for copies of your W-2s or your pay stubs. You can talk, and they can talk about salary expectations. So I would be very careful, if I were you, when you're talking about kind of salary and when you're starting a new job, to make sure that you're framing it away about, this is my salary expectation. Not, well, right now I'm making X amount, I would expect at least that amount or an additional 50,000. I've had clients wonderfully, as a result of this law, see their compensation, double when going from one job to the next, because they were so underpaid and they were able to come back up to market rate by making a job move. But that's only a result of this law that prohibits a discussion about prior salary. So, again, some of the negotiation leverage that you have at the beginning comes from the fact that you're desirable. There's a reason that they're making this offer to you. Don't undersell kind of your value in that process. There are ways that you can inform yourself in this process so that you can be the best advocate for yourself. So there's lots of resources on the internet that you can use to check out, what is market for this type of position? What are people saying who are there or who were there before about, the environment that you're working in? So do your homework. You can also reach out to people who are there internally. Use that network, both your direct network and the network of the people around you, to mine employees for information. Another thing that the law prohibits is any sort of restrictions on employees talking about their compensation with other people. So, it's absolutely permissible to ask people, what's the pay look like? What are you making? It's absolutely permissible for you to provide that information to people who ask you. To say, yeah, here's where we are. This is what's standard in terms of option awards when people come in the door. Companies really, really like it when people keep their comp information and equity information close to their chest, because a lack of transparency means that companies can pay people unfairly. Companies can award less options to one person than they award to another person. So, the tool that you have is sharing information. And, again, we've seen companies where there are these sorts of internal resources where people are sharing information. But remember to kind of extend that outward and to seek it inward when you're negotiating a move across companies. Think about, are there other red flags when you're starting the employment relationship? Is there a high level of turnover? What does that say about the culture? What's been reported in the press about it? What other things should send a signal for you that, maybe this isn't the right fit for you, or maybe you need to work in some additional protections for yourselves. So with that, I'm going to turn it over to Maya. And I should just note, again, if people have questions they want to send us as this is going on, feel free to do that. But we're also going to have a time at the end to talk about any questions people might have. So Maya's going to talk with us now about discrimination and harassment on the job.
Sure, thanks, Kara. So, I think one of the questions that often poses itself to us while we're employed in our workspaces is sort of like, are other people being treated better than me? And, that can be sort of a quiet thing that we keep in our heads, but it could be based off of experiences that we sort of accumulate over time. And so, I wanted to just go forward to explain to you guys sort of what constitutes discrimination and sort of what you should be looking out for in your workplace, in your place of employment. And so Title VII is the federal law that protects employees of employers of 15 or more employees from discrimination on the basis of race, color, national origin, religion, and sex. And as of a week ago, now we officially have a statement from the Supreme Court that sexual orientation and gender identity are protected under Title VII. But in addition to this federal law, we also have state law, and New York has done a pretty impressive job of broadening the protections for employees when it comes to discrimination and harassment. They've expanded protections not only on the basis of sex and race, but also to protect individuals who fall into the classifications of sort of military status, marital status, partnership status, that reaches discrimination on the basis of age, as well as citizenship status. And so there are really broad protections that are available to employees in the workspace. And it can also be a question for employees sometimes to understand sort of what constitutes discrimination. And it can look as small as, a counterpart of mine who isn't a member of my classification was given a mentor or was sort of tracked in a way to be better set up for a promotion or a raise. Someone else was granted leave. And I was denied that same request. And so, these are things that you should be looking out for when sort of reviewing how your employer is treating you in comparison to your counterparts when it comes to promotion and raises, leveling, performance evaluations, and pay and leave. And so, we'll talk more about some of the ways that discrimination can be proven, and so the theories of discrimination going forward. But these are some points that we can talk to. And if you have questions about sort of what else might constitute discrimination on your workplace, please feel free to put those in the chat. So we'll move on to discrimination and harassment. The next slide. Great. So, sexual harassment has been, due largely to the brave efforts of many women and allies in the tech industry. and the cause of the Me Too movement has really come to the forefront, and these narratives have been amplified um, in sort of the public and in the news recently. Um, but unfortunately, the majority of incidents of sexual harassment do go unreported. And so 60% of women say that they experience sexual harassment in the workplace. However, 90% of employees who experience that harassment don't file formal complaints. And so, 75% of those sexual harassment charges also come with claims of retaliation. So, these statistics paint a picture of sort of what the impediments are for women or people of color when sort of contemplating whether to raise issues of sexual harassment in their workplace. And so, there are clear deterrence for employees if they believe that, one, their company has failed to really institute meaningful avenues for them to report incidents of sexual harassment. That would deter anyone from wanting to really openly disclose what's been happening if they, lack the confidence in the company to really responsibly investigate and address the events. And so many choose not to report. The fear of retaliation is also something that employees are considering when making these decisions. But we will note that the largest ethnic group to file sexual harassment claims with the EEOC are Black women. So perhaps the statistic sort of speaks to the prevalency of these experiences for women of color, and also many of the events that result in harassment occur at the intersections of identity. And so we just want to sort of note that, while we're speaking generally about women and people of color, oftentimes the intersectionality of these experiences can be the place where the harm is occurring. But in addition to sexual harassment, there are a number of other forms of harassment that are protected under federal and state law. And so, those in 2019, New York adopted broad protections against all forms of harassment, which expanded the protections not just for sexual harassment, but for incidences of race harassment, religion, and a number of other classifications. And so it also expanded this protection to all employers, regardless of size. And it also reduced the standard that was required for this activity. And so previously, in order to prove harassment in your workplace, you had to show that the events or the activities were severe and pervasive, meaning that they persisted over time, or essentially that they were so severe that they created a hostile environment for the employee. So that's no longer the case. And so, we encourage individuals to really sort of take note of sort of what's taking place in their workplace, even if it seems like, it's one act that is relating to your classification as a woman or a person of color that can constitute a claim of harassment. And so, these things I think are important because oftentimes I think as women and people of color, we classify our harms as sort of microaggressions or things that aren't really cognizable under the law, and that's just not the case. And so, even those small incidences that happen on a day-to-day basis that might make your workplace a little bit more uncomfortable for you or result in sort of our inability to progress at the same rate as your white or male counterparts, those things constitute harassment or may constitute harassment and could be cognizable. I think, one thing to note, particularly about the tech industry, is that, they're due to sort of, like I said, the insularity of these companies and sort of the culture that's created there, these really can be breeding grounds for these types of environments. And I think that as women and people of color, it's important to not normalize those cultures, right? And also realize that we have the same right to feel comfortable and be able to progress in our careers in these companies. And so, here's another example of a way that the law can address those things if you are feeling that your environment is not treating you equally or as well as your white or male counterpart.
Yeah, and I think there's a few other great points to think about in that same context. Sometimes I hear clients say to me, well, they're going to say that I went along with it, right? Like I was laughing at the jokes or like I made jokes myself and, it made me uncomfortable. I didn't like it, but, from all appearances, it looks like I was fine with it. The law recognizes that someone who's in that position is going to feel the need and the strong pressure to, get along to go along, go along to get along. So, don't think that that automatically means that you don't have any rights. Another thing I hear a lot of times from my clients is, well, it's going to be a he said, she said, right? Like, that's okay. Your own testimony, your own experience has power, and that can be enough to show that what you've been experiencing is discrimination. I think one of the powerful impacts of the Me Too movement is this idea that women's stories alone should be enough for them to be believed. And the law is consistent with that. The law says, well, if it's a he said or she said, we get to decide who we think is credible. You don't have to have written proof. You don't have to have, a video or a audio recording of it. Does it help? It can. Yeah, absolutely. But it's not necessary. So don't limit yourself when you're in that situation to thinking, well, there's nothing I can do about it. People often say, well, then, how do we prove discrimination? Like, how do you prove what's going on is because I'm a woman? There's lots of ways we can do that. A strong way is to look at how you're treated as compared to a man or, a person of a different race. And the law says, well, if you have that and all other things are equal, we'd expect you to be treated equally. And if you're not, we can draw an inference from that your gender or your race has something to do with it. Sometimes it's about the timing. The law also says, for instance, for retaliation, if you make a complaint and then 2 weeks later something negative happens, you're allowed to believe that those two things are connected because of the close time of it. So there's lots of ways that lawyers like us can prove that discrimination is a part, and the law gives us lots of tools to use to do that. So what makes the key to the discrimination laws is that your protected category, your gender, your sexual orientation, your gender identity, your family responsibility status, your caregiver status, your military status is one of the reasons for what's happened to you. It doesn't have to be the only reason, but it needs to be a part of the equation. And where it's a part of the equation, the law says, well, then the whole decision, the whole action is suspect. There's another powerful tool that we have, though, and that is with respect to pay equity. One of the ways that discrimination most commonly manifests itself is in pay, and it's a place that really hurts, right? It hurts to be paid less. It impacts your living, your quality of life. It impacts your legacy to your family. It can become generational in its impact. And so the law gives us another tool to attack pay equity. The discrimination laws focus on, well, is this happening because of your gender, because of your race? Pay equity says, doesn't matter why it's happening. If it's happening, it's illegal. So New York's equal pay law says that people should be paid equal pay for equal work. Notice it doesn't say you should be paid equal pay for identical work. It doesn't say, you are paid equal pay if you can prove that you're doing exactly the same thing that someone else is doing next to you. It says equal pay for equal work. And equal work is really this concept of, jobs that are performed in, in similar fashions, in a similar way. So, two engineers as opposed to an engineer and a janitor. Jobs that require the same sorts of skills, experience, etc. Right? So, a manager job versus an entry-level position don't require the same skill set. But to the extent we're talking about, an engineer in this group and an engineer in that group, they should be treated equally for purposes of the equal pay law. We know that doesn't happen. In the upper right-hand corner, you see a chart that relates to, when a person, depending on where they're situated in terms of race and gender, are paid, reach a pay parity to a white man. Now, people say, well, that's different because, people are in positions that contribute to pay equity, and that's true. But we also know, again, that women and people of color who are performing the exact same jobs even are not paid the same. They're underpaid. Um, and you don't, again, have to prove that it's for a discriminatory reason. You don't have to prove it's because you're a woman that you're underpaid. You just need to show that you're performing equal pay for equal work. The intent doesn't matter. Um, Equal pay is defined broadly. So it's your base salary, what you're paid, biweekly or twice monthly. It also includes your equity, because there's a recognition that equity is a form of compensation. And if you're in tech, it's a big form of your compensation. It's what people work for, right? To have the potential upside down the road. It includes benefits. Are you getting the same in terms of paid leave? Are you getting the same amount of vacation time? Things like perks, right? Car benefits or housing allowances. All of that is a part of that question of what's equal pay. Again, the case that we have against Google is a good example of that. And here there's this intersection between pay and discrimination, which often happens in the workplace, right? So the question is, and what we often see is issues around entry level, and your entrance, right? What is your leveling at the time you're entered? And how does that affect your compensation, right? Is a man leveled at a 7 and the woman who's doing the same exact job is leveled at a 6? And there's all of the impact that flows from that in terms of how you're paid and your equity awards. Is a white manager leveled at an M2 and a black female manager is leveled at an M1, and all of the impact of that, those are other ways that pay equity manifests itself. So don't think, well, I don't have a claim because he's an L8 and I'm an L7. That decision to make him an L8 and you an L7 may itself be discriminatory. But again, if you're doing the same job, the level doesn't dictate what you should be paid, unless there's a legitimate reason for that. So we're going to turn it over now to talk about, what your options are when you find that your company's fallen down on its legal obligations.
Thanks, Kara. Just one more point on the leveling, since you brought it up. I think we have a question in the chat. Someone asked, if your hiring manager or recruiter tells you that you will start at a level X, but will be promoted to the next level within 6 months, how can you hold them accountable?
That's a very common, right? The bait and switch. We're gonna promise you this so you come in. Also happens with bonuses, right?
Right.
Don't worry, we can't put it in the agreement, but we can tell you you're going to be paid this much. Unless it's in writing, it's really hard to enforce it, especially if your offer letter or your employment agreement says something like, this is the whole deal, and anything else that was said to you, isn't enforceable. That being said, the more documentation you can get around it, the better. So things like getting emails from the recruiter or emails from the supervisor. If they don't send you that kind of communication, diplomatically send them an email that just memorializes that this discussion occurred. If you're not comfortable doing that, take notes for yourself, right? Contemporaneous notes. This is when it happened. So that if they don't follow through on your obligation, you can follow up, right? And sometimes there's an innocuous reason for it, right? The supervisors changed and nobody passed the message on that this was supposed to happen. And so I've seen employees then go to their company and say, hey, this is the discussion, this is the date that discussion took place, here's the email, and the company makes it right? Like not every company is trying actively to screw their employees. So sometimes, that works. Other times there needs to be more, and sometimes it actually, moves to litigation when it doesn't occur. The goal, I think, generally is not for there to be a lawsuit. It's for people to have their rights protected and to get what they're entitled to. And so, I guess the answer would be do as much as you can to document
it. Great. Well, that ties into the next slide too. I mean, I think that was my first point. There at some of these companies and some of these sort of, I guess, processes are new, right? And have been created at these companies as a result of sort of brave individuals either speaking up and notifying their employers of these incidents of discrimination really before there were real processes for redressing them. And so, we're seeing now that more companies are taking note and really trying to structure an appropriate complaint process. And so, I'm not depending on, where you're employed, particularly for some of these smaller tech companies, there's really now a push to get their HR and diversity initiatives sort of in order. And so perhaps there is a mechanism for you to file a complaint and or talk to your supervisor. Like Kara said, litigation is not sort of the first step. Oftentimes these issues could be resolved through communicating with your supervisor, raising it with HR, filing a complaint, and sort of trying to negotiate your better standards or better experience for you without having to proceed through more formal forms of redress. Additionally, we always advocate for sort of the harnessing the power of collective action. And I think this is a place where not only women and people of color, but their allies can really support creating a more equitable workplace. So we've seen this as Kara mentioned earlier, with the Google walkouts, also with a number of other strikes that sort of employees are banding together to demand that there's better treatment and more equitable pay at their companies. And so, there are a number of protections, one being the NLRA, which is the National Labor Relations Act, which protects employees who are acting together on behalf of one another to improve their situation. And so, these activities are protected under this law. And so this is a way to sort of, resolve or reduce any concern you might have about retaliation as a result of this activity. And then another part that sort of Kara talks about in terms of the pay equity piece is just sharing information. Here is a prime example of how a white man or someone who's not sort of experiencing that discrimination on a day-to-day basis can assist others in really solidifying a claim for them to raise to their companies. In addition to those sort of initial steps, there are clearly pathways to litigation. And so, one of those is individual litigation, which is just you and an attorney-client relationship with an attorney, and really focusing on sort of your specific claims, the issues that you're facing in your employment. And so those can be sort of done in a number of ways. Also there is the class and collective action. And sort of we see sort of two benefits that come, you are able to redress your individual concerns, but also often these cases result in really widespread and systematic change in terms of policy and practices that might be disproportionately impacting people who fall into your same classification. And so, one example of this is our Uber case. So this is Del Toro Lopez versus Uber. This is a case in 2018 where our firm was able to reach a settlement on behalf of women and people of color who were employed as software engineers at Uber. And so, in addition to a monetary sort of fund that resulted from this litigation, really substantial programmatic relief was also awarded. And so, Uber was then required to go through a 3-year monitoring process of their compensation structure to ensure that no adverse impact was being had on people of different races and of women. They were forced to sort of recalculate their evaluation process to ensure that the standards and the factors were objective and based on merit, rather than more subjective and based off of sort of, looser terms that were able to be, manipulated or I guess affected by bias. And then also they were required to create and establish more valid standards for hiring. And I think, particularly in this field where sometimes, the fit of an employee can really determine whether they're hired or not. We've seen this particularly in sort of some of these smaller gaming startups where, are you a gamer? And, in the recruiter's mind, there's a specific person who is a gamer, right? And oftentimes for women or people of color, they may not fit that sort of stereotype of what the company believes that a person of the correct fit is. And so, instituting really concrete and objective standards for hiring is one way that we can really redress sort of discrimination at the onset. And additionally, mentoring was a piece that was helpful, right? Clearly, we all know that there's a benefit to having someone sort of help you to chart out your career trajectory, and the more women and people of color who are employed at a company, clearly the more ability there is to be partnered with someone of your same classification or someone else who's able to help you sort of navigate the employment relationship. So this is just an example of sort of what the outcomes can be, and we just want to sort of express that there are a number of ways that you can challenge discrimination in your workplace, and not all of them sort of result in the heavy lawsuit, but there are also a lot of really great benefits to joining together through the collective action framework.
Thanks, Maya. So, we wanted to talk briefly about what happens when the employment relationship ends. Ends because you want it to end, you got a great job somewhere else and you are happy to make a move. Ends because of a global pandemic and the company's making layoffs, or ends because, the company's treating you badly and has, said that they think you have poor performance, or, you're not a good fit for the company, or other things. So here's what to think about when that sort of situations happen, where your employment is ending. One, you want to think about the reasons for the termination. If you're electing to leave because you have another great opportunity, great, that's great. We'll talk about what things you should consider in that circumstance. Sometimes you're electing to leave because they've made you so miserable that it seems the best outcome is for you to find somewhere where you can be happier. That can also be a good thing, right? Change can be a good thing when you're in that situation. But they may still be liable to you for the misery that they caused you if it was discriminatory. So even though you're choosing to leave, you may still have recourse. But it's important to kind of reach out to an attorney to understand the best way to leave in that situation to keep all the rights that you may have. And so all of that relates to, wrongful termination, where the company has terminated your employment. They may be seeking for you to sign a separation agreement, an exit agreement. So let's talk about, we're going to take these a little out of order. Let's talk about separation agreements for a minute. Separation agreements are something a company gives you, and they usually offer, to pay you some amount because they want something in return. For most circumstances, you're an at-will employee. That even where you have an offer letter, it very often includes language that you're an at-will employee. You can be fired for, good reason, no reason, bad reason. The exception is a discriminatory or retaliatory reason. A company can't fire you for those reasons. That's unlawful. But you're otherwise not entitled to employment for a specific term. So when the company gives you a separation agreement and they offer to pay you severance, it's because, again, they want something in return. They want you to release any claims you may have against them and waive any rights you may have to pursue claims against them. That's a big one, right? Sometimes they also want you to agree that you're not going to talk about your circumstances, a gag order, a non-disclosure agreement, a confidentiality provision. They want to pay you for that. They want to pay you for secrecy, right? They want to pay you to not talk to the media. You see these types of clauses in there. They want to pay you to not go to a competitor. And so bear in mind that this is not just kind of a benevolent offer of severance to help you get, because they've let you go. It's because they have an ulterior motive. The good news is that means you have some leverage very often in this situation. If you have a discrimination claim, the value to the company of that release goes up. If there's something you can talk about and you're okay with, giving up your right to talk about it, that's leverage. Talk about non-disclosure agreements for a minute. There's a real pushback against them, and rightly so, right? Too often they've operated to insulate the company from any sort of accountability and to harm other people who would have otherwise been on notice of bad behavior, who would have known, this is a company where these issues are happening, and they've really harmed employees. And so some states have prohibited those sorts of non-disclosure agreements, or said when you're terminating someone's employment or you're offering a severance package, a non-disclosure agreement can only be there if it's the employee's choice, if the employee wants it. Sometimes employees don't ever want anyone to know what happened to them, and it's a strong personal preference that they have. But outside that situation, it shouldn't be an automatic, the company gets to lock you up from talking about this forever. The other piece, in addition to the money and in addition to non-disclosure agreements and in addition to release of claim, that's very often addressed in the separation agreement is the non-competes, right? Are you going to be able to go to another tech company? Are you going to be able to solicit employees to come with you, right? Take your team with you and move, or take your best friend with you, your girlfriend or boyfriend. Are you going to be able to do that? And this also is something that is addressed at the front end. If you sign a restrictive covenant agreement where it says, for a period of time, you will not compete, and this is what competition means, or you will not solicit. Two things to note on the back end about that. One is that these sorts of agreements are disfavored in New York. New York wants free enterprise. It wants, competition. Competition's not a bad thing. And it only recognizes non-competes or non-solicits where it would be necessary to avoid unfair competition. Competition itself is a good thing. Unfair competition is what the courts are worried about. And if your employment has been terminated without cause, New York has taken a position that those sorts of non-compete agreements can't be enforced, because a company can't say both that, you can't work here, and also say, and you can't work anywhere else. That is prejudicial to the employee who needs to support themselves, may have a family to support, and otherwise. So a non-compete on the back end where the employer has terminated the employment can only be enforceable if the company gives you additional consideration than you're already entitled to. They're paying you something extra. And so you then have a choice. Do you take that extra and sign up for the non-compete, or do you decline and have your right? These are really kind of case specific, we say. Right? So it's really going to depend on your personal circumstances, how the non-compete operates, whether it's enforceable, what the value of the non-compete might be. So this is a really, really good time to talk to an attorney and get some advice about, how you should handle a non-compete when you're leaving. If your employment has been terminated in retaliation, that's illegal. If it's because you complained about discrimination or blew the whistle on certain, protected activities, et cetera. So, we've talked a lot about discrimination, but retaliation is kind of the other side of the coin. And sometimes it's easier to prove a retaliation claim than it is a discrimination claim, because you don't have to prove that it's because you're a woman, and we can look at the timing of things and otherwise to say, yeah, it's retaliation. So I'm going to turn it quickly over to Maya to talk about what your options are.
Great. So we talked about this a little bit earlier, but, one of the functions that I think is sort of less known is that, engaging with counsel can really just be in the form of sort of consultation. Oftentimes we're able to speak with you to give you some sort of tips on what questions or points to make when you're sort of negotiating between your employer on your own accord. And so, this is what we call behind the scenes assistance. And we're also here to represent you sort of during negotiations in that process. This process for a lot of folks is really preferable because, I think, as you could assume, many employers aren't super happy when they find out that you've retained counsel, perhaps, and are now sending them sort of a formal demand letter. And so, for those, particularly for those who are interested in sort of staying in their employment relationship with their current company, this can be a viable sort of step to addressing any concerns that you're having in your workplace. And then additionally, we spoke a little bit about litigation. Depending on what type of claim you have, there are sort of preliminary steps that you might have to take through an administrative forum before filing a formal complaint in court. And so for, under New York law and also under Title VII, there are sort of administrative charges that have to be filed within the requisite time period in order for you able to sort of preserve your claim before moving forward with litigation. And so, these are things that you should be aware of in terms of the time frame between the harm that you're experiencing in the workplace and sort of the time, the deadline for when you can raise those claims. And additionally, we often sort of start out with the mission of settling some of these claims, right? So the process looks like, drafting a demand letter to really open up negotiations with the employer. Oftentimes these are concerns that, they also don't want this to be publicly disclosed, that they have, a problem with pay equity or that they have a problem with discrimination in their workforce, particularly for some of these tech companies who like to sort of tout their sort of more liberal or progressive culture. And so through sort of private settlements and negotiations, that's a way where sometimes we're able to redress some of the harm that's happening. Did you have anything else to add, Kara? Okay, great. Well, so with the remaining 4 minutes or so, and we're happy to stay on for a little bit longer, we can take a few questions. There are a few in the chat already, and so I'll just read them and feel free to add any additional ones as I speak. The first one says, can anything be done for prior salary questions asked before this law was passed? So, I think Kara.
Yeah, so if they asked you prior salary at the time, it was still lawful to do so, and that impacted your compensation, there's not a lot you can do about that. However, to the extent that the result of that is that you're underpaid as compared to your colleagues or as compared to specifically people who are of a different gender or different race, you may have an equal pay claim. I think different employers respond differently. Some are receptive to, a conversation that, I've been here a long time. My compensation hasn't kept pace with the market, and we'll evaluate that, right? Very often, and we didn't talk about this before, but women can be impacted because women tend to stay in positions longer than men. And so while men have the opportunity to renegotiate their compensation every time they move positions, women don't always have that same opportunity if they stay at a job for a long time. Tech's a little different because we already talked about how there's a much higher rate of turnover among women. But some employers will consider that. I would say if that happened to you, it's very likely you may have a pay equity claim under the pay laws. But certainly you can raise the issue and should raise the issue that you're concerned about whether your pay has kept pace, given that you've been there a while and other people have been hired since.
Someone else asked, can you talk about adding language to the employment contract that protects for disabilities, that's including sort of flex hours for appointments, taking sick days, especially at companies that have unlimited vacation? I'll just note that this is a favorite in the tech industry to sort of provide these really sort of grand additional benefits, extended vacation, free food, free sort of gear, in the workplace, and sort of, a lot of these things can be sort of additional, but there could be lacking sort of the core elements of what is required for an equitable sort of policy for leave. And so, I would just note that, if you feel as though based off of, your classification that others are being able to receive leave or take leave or aren't being penalized for taking leave when you are, if that's related to your classification, then that's something that may perhaps be cognizable. I don't know, Kara, did you have anything else?
To add to that, whether it's in your agreement or not, you are entitled to the protections of the disability laws. And so that's, a whole other area. New York City has a disability aspect to its human rights law, as does the state. There's the Americans with Disabilities Act. An important concept in there is the right to reasonable accommodation. And so accommodations, I think sometimes people think, oh, well, that means, if I'm in a wheelchair, that the employer has, a lift that I can use to get up and down the stairs. It can mean that. It also, though, can mean things like flexible work schedules or, the ability to work from home on occasions or, a different way of communication. I have clients who have ADHD or otherwise where they need instructions in writing as opposed to, verbal communications around what they're supposed to be doing. Getting instructions in writing can be an accommodation. There are also leave laws that give you the right to take time off in connection with a disability or a serious health condition that you may have. And so that can mean there's different leave laws that apply depending on the size of your employer, but most leave laws also recognize this idea of what's called intermittent leave. And that's leave that you take on a kind of an hourly basis, right? Like maybe you just need to leave 2 hours early to go to a doctor's appointment. This is something intermittent leave laws used a lot in the context of fertility treatment. So people who are undergoing IVF, they need to go to the doctor a lot. And these leave laws say, we can accommodate that. It's not only the situation where you need to take, 8 weeks off because you're undergoing cancer treatments. It can be, more accommodating to these kind of chronic conditions or, ongoing disabilities that also require the same sort. So the answer is you can negotiate it for in your employment agreement, but even if you don't, you likely have a lot of protections under the disability laws and the leave laws.
Okay, let's see. One other question. Does New York law apply to the headquarters of a company? It sounds like the global company is headquartered in California, but there's an office in New York. It really depends on where the harm is taking place. If you're currently in the New York office and are experiencing discrimination in the New York office, then New York law may apply. But I don't know, Kara, did you have anything else to add on that?
Yeah. So remember, that there's different laws that cover the same thing, right? So there's the federal law, Title VII, which is nationwide.
Right.
There's state laws like the New York State Human Rights Law. There's local laws like the New York City Human Rights Law. The federal laws apply wherever you are in the United States and wherever the company is in the United States. The local and state laws generally apply to where you work. So if you are working for a California company in New York, it's the New York laws that apply. If you're working for a New York company in California, it's the California laws that apply. New York takes a more generous view of who its laws apply to. So maybe, your company's headquartered in New York, but you work remotely from Minnesota. So the law says, well, do you have a connection? Do you come to New York for work? Are you coming out here on a quarterly basis? Did any of the events at issue happen here in New York when you were here? So just because you're not working in New York, if you have a connection to New York, you may still qualify for the laws. And if you are a U.S. employee who's working on an expat agreement in another country, so Google has sent you on an expat agreement to Germany, you may still be protected by the laws of the United States. So again, it's going to depend on your circumstances, but don't just assume that it doesn't apply to you or that you're not protected.
Yeah, only thing I would add to that is that California also has pretty progressive sort of laws that expand beyond sort of the federal law as well. So you could be covered both under California and New York law for the same harm. Okay, a few more questions. If your manager provides consistent positive reinforcement to your counterparts and completely ignores you, is that a form of microaggression? If you are consistent, if your counterpart receives additional one-on-one support and coaching, setting them up for success, does that fall into this category? If you're never informed about options for additional interviews or promotion, that constitute discrimination.
Do you want me to take it or do you want to take it, Maya?
I mean, sure, it definitely does. I mean, I think that we've spoken about this a little bit, but those are essential elements to anyone's sort of progression throughout their career. Mentoring, access to sort of licensings that would, make you eligible for promotion. Those are all factors that sort of when culminated, really do show whether there was like a difference in treatment. And so, I think that one thing to note is, like Kara said earlier, it's important to just record, one, times in which you've requested those things and been denied them and seeing your counterparts sort of be given them. But definitely, these are elements that are not just sort of small microaggressions that are, you're being sort of overlooked. These are really and consistent impediments to sort of success for women and people of color. This is the idea of sort of being invisible, and this is a common narrative that we see for both women and people of color in their workspaces. And so, these are definitely elements that constitute discrimination. And, if you feel like you've been denied a promotion or, wrongly leveled or denied equal pay as a result of not being given these opportunities, those things are definitely cognizable.
Yeah, and that's one of the places where the distinction between the federal law and the New York laws is very different. The federal law says, well, it has to be a material adverse action, right? We're talking about like a promotion or being fired or hired or like a compensation decision. And the New York law says, well, no, we want to attack discrimination in all of its forms. And so if you're being treated less well, which includes things like opportunities or performance evaluations or mentoring, we want to challenge that as well. We talked a little bit before about like raising the alarm internally, a complaint. New York's law says, a complaint doesn't have to have any sort of magic language. You don't have to say, I'm being discriminated against, or I want to file a formal complaint. It's enough to raise the concerns. The thing I would say about that, though, is don't kind of walk away from the fact that gender or race or a combination of the things or sexual orientation or another protected category is part of what's going on, because a general claim of unfairness is not a protected activity. There has to be some connection. People do it in different ways, right? Like, I have this concern, I'm being treated this, I look around and I see my male colleagues have this experience, right? That's a concern of discrimination. You're not saying discrimination, but you're pointing out that you're not being treated the same way as this, these other people in this other category.
Okay, a few more questions. For the New York law that says that you don't have to prove intent to challenge pay disparity, does that apply to all organizations or only organizations of a certain size? As of 2019, I believe it's expanded to all employers, right, Kara? I don't think.
Yeah, so the New York Equal Pay Law, interestingly, is part of the actual wage and hour laws of the country, of the state, I'm sorry, as opposed to like the discrimination laws, because again, it's not about intent, it's just about wages. The key with the Equal Pay Law is that it's based on location. It has a geographical component of it. So for both the federal and the local laws. So you're not comparing yourself to, I'm here and my colleague in California is paid differently. That may still be a discrimination claim, but it may not be an equal pay claim. It's, I'm here in New York City, my colleague here in New York City, I'm either in the same office or across town or, in Brooklyn, is being paid more. So that's a key component to consider.
Someone also said, as a female person of color, I sometimes notice that I'm treated differently or better than other people of color, and that makes me uncomfortable. How can I address this in my workplace?
Yeah, I mean, this is a hard one. Maya, do you want to talk about it or do you want me to?
Yeah, I can. I mean, these are the things we sort of pointed out earlier, but, to the extent that you can be transparent and sort of be that bridge between the employer and your coworkers for issues of pay equity or other treatment that you're receiving. And so if you see that, you've been given a mentor or you've been, allowed some access to a program that someone else sort of wasn't offered, I think those are things that, really benefit from transparency. And so if you can communicate with your coworkers and create a network where that information is shared, that's one way it's one way for you to sort of alleviate those concerns. But I also think just support, right? Standing up with other folks who are voicing their opinions and voicing their experience is a prime way to be an ally, and really impressing upon your company that it's not an individual issue, right? That you want to also work at a more equitable employer and a more equitable company. And so really to encourage the company to sort of hold itself to the mission statements that a lot of these tech industry companies espouse to. And so that's one point I'd make. I don't know, Kara.
Yeah. Yeah, I think another point is that you can have some comfort that you have protections under the law. So we talked about anti-retaliation provisions where the law says, an employer can't retaliate against someone raising concerns of discrimination. And an important point is that it's not just raising concerns about your own treatment. It can be raising concerns about other people's treatment. So if you say, look, I look around and this is what I'm observing, that's not fair, that's not right, that's not consistent with our values, and the company retaliates against you for that, you're likely protected under the law. So, to the extent people may hold back in being, a true ally in the workforce, know that the law is designed to protect you as well. And, it's in all of our interests to speak up, to hold companies accountable, and to push for more equitable workplaces.
Great. Well, I just want to thank everyone who took the time to join us today. And on this last slide, you'll see our email address again. So if there are any questions that we weren't able to get to or any sort of concerns that popped up while we were speaking on this presentation, feel free to email both Kara and I at this email address. There was another comment asking whether there'll be a recording. If so, we will send that back out through the same mechanism that we sent out the invite. And then also, if there are additional sort of resources that you're interested in receiving from us, feel free to email us at this email address also, and we're happy to provide you with some additional brochures as well. So again, thank you so much. I don't know, Carrie, do you have any parting words?
Nope, thanks. It's been a pleasure.
Great, thanks.